Also
you
offered.
have to be a retard to be in jail with someone that the court ordered you in 2 files not to have contact with. I recognize that. You know how I recognize that? Because you got it tattooed on your head right now. But there's a court order. Do you know what a court order means? Or are you above the law? No, that's not how it works. You don't get to decide that I don't want this one, I get another one. Excuse me? Who's y'all? Y'all keep postponing. I ain't y'all. That's number one. My name is Judge Simmons to you. Mister, I got Brittany tattooed on my mind. Because I guarantee you, I will run it up in here. I will charge each one of them individually. And you will get 93 days on each and every phone call. Do you understand that?
I got something to say.
I don't want to hear it. Bye.
This might be one of the most disturbing courtroom cases I've ever seen. A man sitting in jail under a strict no-contact order still managed to call the same woman hundreds of times, completely ignoring the law. He's already facing serious domestic violence charges, yet he treated the jail like his personal call center. What makes this even crazier is how confident and delusional he sounds, arguing with the judge like he's the real victim. But when his attitude finally crosses the line, the judge shuts him down in the most ruthless way possible. Trust me, this one escalates fast.
Today was the date scheduled in both files for preliminary examination. There's an assault with intent to do great bodily harm, interfering with the crime of court, domestic violence third, and interference with electronic communication. Then another DV third, and assault with a deadly weapon. My understanding is that the prosecution had a request or a special request.
Yes, but first, as we got sidetracked, Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you. Did you get your appearance? I don't know.
Oh, I don't think, okay.
Nope.
Jeffrey Kaplan, P74943 on behalf of the defendant who's standing to my right.
Okay, thank you. Okay, and what was the request?
Your Honor, the people will be requesting a hearing today for a couple. First, I'll take this in chronological order as it happened to me. This was originally set for a preliminary examination back in October. I was in trial at that time. I had Cassie handle that for me. And based on those notes, there was an adjournment requested by the defense, 21 days.
He was also in trial.
I was in trial with Mr. Fife.
Yep.
Oh, okay.
Okay. I was in a string of them. I couldn't remember if it was the one we had together. Different public defender substituted in, felt they needed more time, so an adjournment happened then. In preparing for today's examination, I discovered that the defendant had called the victim between that original hearing and today. Hold on, it changed because he called her 7 more times last night. 240 calls, 66 pages of messages, and more video visits than I had the time or will to count yesterday. I forwarded these over to Mr. Kaplan, and I said, this is what I have. My intention is to ask for a continuance to start with the officers, and then get a continuance to have the detective look at these, review them, make a more formal report, because just based on the e-messages, it's lots of manipulation. I love you so much. When I get out, I'm going to be able to take care of us and our baby, and I'm facing 7 life sentences, and this is so terrible. Things like that traditionally influence a victim to not testify and to remain on his side. And that was just from the e-messages, because those are far easier to scan through than calls and video visits. I also offered.
This is crazy.
Yep. I also offered.
You have to be a retard to be in jail and video visit with someone that the court ordered you in 2 files not to have contact.
Did this man really insult himself while admitting he was secretly video calling the victim from jail? That might be the most accidental confession I've ever heard in a courtroom. And when the prosecutor revealed the real number, over 240 calls, it was honestly unbelievable. How does someone even find that much time behind bars? This isn't romance. This is obsession. He clearly thought he was being clever, but instead he was creating a mountain of evidence against himself. Every call, every message, every video only made his situation worse. So let me ask you, is this love or is this straight up stalking?
Mr. Willie Green, no Lee, is not a retard. Are you?
So I offered to waive the examinations up because Mr. Green is on dead time. So adjournments are not in his favor because he's on a parole hold. So I offered to waive these up today, so they're up to the circuit court faster, and work out a plea agreement where traditionally what I often include is I won't pursue witness interference charges before this date, as part of the eventual agreement. And it's my understanding he wants to run the examination. So prepared to run it, waiting for an officer to get here. Had another officer call him.
With its interference and bond violation.
Correct, Your Honor. P53s as well. Able to get a hold of the officer. To his credit, he was upfront with me that he forgot that he had court today. He didn't say he was sick. He didn't say there was an issue with the subpoena. I asked him point blank. He said, no, I'm pretty sure I got it. And I just screwed up. So my officer is not here because of that. So those are the two reasons I'm asking for an adjournment. But the other thing I want to make the court aware of is that this is not the first time that Mr. Green has done this, because when I went to save these e-messages to my computer, it said I already had a file under that name. Because when I last had Mr. Green in 2023 for other felony domestic cases with the same victim, he did the exact same thing back then, where he was calling her and messaging her and using other inmate accounts over and over and over again. So he knows he's not supposed to.
Also, he said, you go to last time.
I don't want you to say anything, because anything you say is on the record. That's exactly what I want you to say. I don't want you saying anything that's going to hurt the case.
So he knows not only he's not supposed to do this, he knows that Adam Pfeiffer, the prosecutor, look into these because I was the prosecutor last time.
The whole jail should know that Adam Pfeiffer is going to. I don't understand why it's not well known.
So because of that, Your Honor, I'm asking for an adjournment in these matters, so that way a detective can listen to the jail calls, write up a report, and then proceed under likely forfeiture by wrongdoing, but then also adding witness interference charges and requesting a PA-53 hearing in each file. And if need be, I can get more into the content that helps identify him despite his attempts to use other inmates.
Thank you. Mr. Kaplan.
Your Honor, I received these an email yesterday with some documentation from Mr. Pfeiffer. I have not had a chance to review any of it just because I'm preparing for other trials right now. This case was originally scheduled for preliminary exam October 9th. As Mr. Pfeiffer said, we were in trial together. Mr. Freeman covered that hearing for me, which is why I couldn't remember the details because it wasn't here. My client did not waive his 21 days. Your Honor granted an adjournment at that time for good cause because
I didn't have a choice because the attorney didn't show up.
Well, Mr. Freeman was here.
No, that's not my note.
Well, he was.
My note says good cause to adjourn because defendant's attorney is not able to appear. Mr. Freeman, I don't believe was here. Preliminary, yeah, that's not the note that I have. Then, and that was two files.
I will say the prosecutor's note, it's limited, but it does match what Mr. Kaplan
Okay,
said.
and then I have that in the other file, Mr. Kaplan failed to appear because he is in jury trial. Good cause to adjourn because I didn't have any of the attorneys here, so I had no choice.
Well, the point being, Your Honor, it was not adjourned because my client waived his 21
I
days.
get that.
Now, the prosecutor is asking for another adjournment for good cause because his officer's not here. As to the other information, that certainly can be charged if the prosecutor wants to charge that. We're asking for dismissal. My client, as mentioned, is on dead time. Prosecutor can always, refile with the new charges if he chooses to do that. So,
He's getting arraigned on bond violations in just a moment. So that's probably not going to work.
I haven't seen
Just based on the prosecution's representations to the court, I have enough to advise your client that he is subject to bond violations. A bond violation proceeding is a contempt of court. And so you are or have the right to have a hearing, a contested hearing as to the allegations that you violated your conditions of release and custody, which says you're not to have contact directly or indirectly with a Brittany Prokofsky, and that you were advised of that on September 21st in both files. And so you're subject to the penalty for contempt of court for each violation. Do you understand that? It's up to 93 days in jail and up to $7,500 in fines. Do you understand that, sir? Are you trying to gather understanding, or are you just maintaining? No, actually, you understand that the contempt of court procedure. So I'm going to assume you're entering a plea of not guilty as to these violations. So the court will have these set out. As to the request for the underlying matter to be dismissed, that is going to be denied because in light of the the new information, I don't know what's going on with the officer. I think if the officer had just blown it off and we didn't have such seriousness of cases, we're talking about domestic violence third in both files. We're talking about assault with deadly weapons, assault with intent to do great bodily harm, less than murder or by strangulation, and then interfering with the alleged victim's ability to make a crime report, to which your client is being charged with an habitual offender fourth offense notice. So this is a pattern of behavior that's being reflected here. Based on the representations of the prosecutor, the victim alleged in this matter, Ms. Brittany Bukowski, this is not the first time she's been a victim. She was also the victim in, I'm assuming, the conviction from 2023 or maybe another case that was charged in 2023. And then there's allegations of video calls and other communication while you're in the custody of the jail after being arraigned on this matter with this individual allegedly engaging in activity or communication that would manipulate and or cause her not to want to be a willing participant in the prosecution of this case. You have something you want to share?
Saying I love her.
Your Honor,
you said you loved her. No, saying you love her doesn't. It's not manipulation. Saying you love her, though, is an admission that you had a communication with her that you weren't supposed to have.
Your Honor, I just want to say if my client chooses to speak, he's doing it against my spouse.
You've advised him multiple times on this record, but he is like he's willing to admit to the violations. I recognize that you can't get Miss Brittany off your mind. I recognize that. You know how I recognize that? Because you got it tattooed on your head right now.
The judge absolutely ended him in this moment. When she pointed out the tattoo on his head, it instantly destroyed his entire argument that he wasn't obsessed. You could see the embarrassment hit him in real time. The mumbling, the excuses, the nervous energy. It's honestly wild and sad at the same time. Imagine permanently branding yourself with the name of someone you're legally forbidden to contact. The judge showed zero mercy, and honestly, she handled this chaos like a professional. But seriously, would you ever tattoo a partner's name on your face?
Here's a court order. Do you know what a court order means? Or are you above the law? I think you think you're above the law. I think you can do what you want. Someone tells you you can't have contact, and you think that because I tell her I love her, that doesn't count. To the contrary, I think the allegations are that you did more than just tell her that you love her. But you don't get to communicate with a person that the court told you you can't communicate with because you have already allegedly assaulted her with intent to do great bodily harm, less than murder or by strangulation. In two separate files, you have a domestic violence third and another time where you allegedly assaulted her with a deadly weapon. You don't get to communicate with her to tell her you love her. You don't get to do that, okay? Okay, and so I don't know, unfortunately, English is my only language. I don't know any other languages I can communicate this to you in, but there's no contact between you and Miss Brittany. And to ensure that, I'm going to suspend all of your communication privileges while you're in the custody of the jail. You will only be able to communicate with Mr. Kaplan.
All right.
You can fire whoever you want and hire an attorney yourself or represent yourself. That's your right. You don't get to get a different public defender. Did you recognize that?
Everybody else, I don't.
I don't know what you're talking about. You don't get to select which public defender you're going to get. Mr. Kaplan is already conflict counsel, correct?
No.
Oh, were you?
There is no conflict counsel.
Oh, you hired him.
No, I'm public defender.
Oh, I didn't know you were at the public defender's office. Okay, very good. So you don't get to select which public defender you get. No, that's not how it works. You don't get to decide that I don't want this one, I get another one. That's not how this works. There is an assignment that was made at the office of the public defender. They handle that. The court doesn't even get involved in that. And Mr. Kaplan was assigned to represent you in this matter. If you don't like his representation.
He's not representing. He just showed up to court. I don't got no police report. I don't even know what I'm in here for. I don't even know what I'm out.
You don't know what you're in here for. You've been arraigned.
I don't know none of nothing. I have no police report. Nothing. I don't even know what's going on.
You're requesting to meet with him to go over the discovery. You can fire him, but then you have to hire your own attorney. That's not how the public defender's office works. You don't get to just swap out and you get another public defender.
I seen multiple people fire lawyers.
Okay, well, you can't. Any other questions about that?
I will make sure he gets discovery in jail. It may take some time, but we'll have a.
Well, it sounds like there's additional discovery coming in. Your attorney and the prosecutor has already represented on this record that at your last court date, they were both in the same trial. So that's probably why you were not able to meet with your attorney to go over discovery. But you were busy allegedly making phone calls talking about your love. Anyways. Excuse me? Pardon? I can't hear you.
There's nobody in here. There's no police, no victims. Y'all keep like postponing my court dates.
Who's y'all? Y'all keep postponing. I didn't y'all. That's number one. My name is Judge Simmons to you, or you can call me Your Honor. The other thing is the only reason why this case was postponed previously is because the attorneys were in trial.
That's only a week or 60 days.
Says who? You decided how long someone else's trial was going to go, and you decided how long I had on my docket or when I was going to be available. You decided that. Why don't you work on deciding how you're going to control your own actions first? Mr. I got Brittany tattooed on my mind. Okay. Decide that you're going to be in compliance with court orders so that you don't get a contempt of court. Because I guarantee you, I will run it up in here. I will charge each one of them individually. And you will get 93 days on each and every phone call. Do you understand that? Your phone privileges are suspended pending a hearing on the violations. Discovery will be turned over to your attorney. Your attorney will meet with you so that you all can go over the discovery. If you fire him, you let us know who you're going to hire. We will get you a new court date. It will be in 2026, obviously.
Thank you, Your Honor. Should I wait for the court dinner?
We're going to give it to you right now.
Oh.
February 5th at 9:30.
February 5th at 9:30.
And that's for the bond violation and the preliminary.
That's correct.
Thank you, Your Honor.
Any additional matters for the record?
Not from the defense, Your Honor.
None from the people. I got something to say.
I don't want to hear it. Bye.
Just want to smart about it.
We're running somebody's or LaPearl.
What did you say? That what is crazy?
Excuse me?
No, what did you say? That what is, yes, you did. You said that what is crazy?
What did you say?
What did you say though? That what is crazy? Did you add additive to that?
That ending was unbelievable. Insulting a judge under your breath while your freedom is on the line might be one of the worst decisions you can make. This entire case is a perfect example of how obsession destroys logic, self-control, and common sense. Sadly, this behavior shows up far too often in these cases. People ignore boundaries, harass victims, and then lash out when consequences arrive. The lesson is simple. Court orders exist for a reason. Break them, and the system will respond. Do you think his final comment made his situation even worse? Drop your thoughts below, and don't forget to like and subscribe for more real courtroom stories.